I figured out the
Hello,
other movies.
hello, and welcome to Privacy Corner. I'm Robert Bateman. I'm a freelance privacy writer, commentator, advisor, and various other privacy related things. And this is Privacy Corner. We do this every other week, and I write a newsletter to go with it, which should come up in your on your screens fairly soon. We look at news developments in the worlds of privacy and data protection each week, and we go in depth on one topic. And today I'm joined by Debra Farber, who I'm sure many of you will know, very well known figure in the world of privacy, globally recognized privacy, security, and ethical tech advisor, and also hosts her own podcast, Shifting Privacy Left, which is excellent. And Debra has 17 years of experience managing privacy and data protection issues and is really, really good on the privacy by design and privacy enabling technologies and those sorts of things. Hello, Debra. Thanks so much for joining us.
Thank you.
How
This is wonderful. Glad to
great,
be here.
and look forward to getting stuck into the news first off. Tell us a bit about your week, Debra. What have you been up to recently?
Yeah. Well, this weekend was my fiance's birthday. So over the weekend and including Monday, which we took off for Juneteenth, which is also his birthday, we just watched a whole bunch of zombie movies. So it was probably not how you expected this conversation to start, but that the day, or I should say, the week was definitely shaped by watching like Army of the Dead, Army of Thieves, Resident Evil movies, 28 Days Later, 28 Weeks Later. So, we kind of dove into that world of like post-apocalyptic survival and gloom. And that was really fun. And then the rest of the week, I had some really different projects. One I'll highlight is I interviewed two different guests for my podcast that I'm really excited to publish, the conversations to. So next week, we'll hear the conversation I recorded with Kim Butts on threat modeling for privacy and the Linden privacy threat model. And the following week, we'll hear from Jeff Jokish about privacy data sets, location privacy, and the challenges with geolocation, and data brokers, and the challenges with data brokers. So just a little bit about what I've done so far this week, and then of course this is another major initiative this week for me to be on this conversation and talking about Privacy Corner. So thanks for inviting me.
Great, Debra. And well, firstly, nice selection of zombie flicks.
Thank
Good
you.
to see the
Thank
UK
you.
represented there with 28 days/weeks later. Also, great guest for your podcast. I know Jeff relatively well, and I'm sure that was a good one. And I should mention as well, Debra is an advisor to Provado AI, who provide this space for me to ramble every fortnight. So thanks again to Privado. So let's talk a bit about some recent news developments. Now, it hasn't been the busiest week in privacy until actually today, where here in Europe, we've had some interesting judgments from the Court of Justice. But I'd like to firstly talk about what I found to be a very interesting story about Grindr's former chief privacy officer, Rhonda Jesus, who I think I've spoken to before in a previous job. He is suing the company after he claims he was wrongfully terminated after raising some concerns about Grindr's privacy practices. Now, Grindr has had issues previously here in Europe, or I should say really there in Europe. Now the UK is no longer part of that, but
sorry.
So the the concerns De Jesus rose were around retention of user data, sometimes obviously given the nature of the app, quite sensitive data, including nude photos being retained after the user had deleted their account, and a bug apparently that allowed widespread access to some pretty sensitive stuff. So this is a bit of a nightmare for many privacy pros, if, of course, these are allegations, unproven, but right. In general, privacy people need to have difficult conversations like this. Have you got any experience of that, Deborah? Because I don't do a lot of advice work, but I do find that really difficult. Tricky conversations. Any tips for people approaching businesses, telling them what's wrong, what they should do, what they shouldn't do, without, in a way that the business can accept?
Yeah, it's a tricky needle to thread, and to some success, to some non-success. I have been in a situation slightly similar that just wasn't, as public, because you also weigh, like, how much do I want to, like, go public with this versus try to get them to, the company to quietly make the change that I request, kind of thing. First, I'll say I know Ron DeJesus. I don't know him well, but we have been in privacy almost at least as long as one another. So I've been 17, 18 years in the space. He has too, because we both interviewed for my very first job at the same time at American Express. And I've been following his career, and on one hand, I would say I'm not surprised that this has happened, because, to your point, companies sometimes want to have a person in a role so that they can externally say, we're handling this. We're handling privacy. We have a guy, right? Or gal, but in this case, we have a guy. But they typically, especially in the past, your smaller company is moving fast, especially if they're in the tech space, or in this case, Grindr scales. Like, there's millions of users of their service and very sensitive data they're collecting. A lot of times in the past, they think about privacy and security afterwards. Now, I don't know. I'm not a user of their service, but I can say that I have heard many people in privacy go through the struggle of trying to convince their CXOs that they need to put privacy practices in place that should, at minimum, be the compliance, but it should go beyond compliance to actually protect people and their data, not just, oh, great, we'll do a risk assessment so we could check a box to say we did one, but you kind of half-ass it. I have faced a similar issue where after a breach in a particular company, this was many years ago, after a breach in a company where I was the privacy officer, and this was early days, this was like 15 years, 2010, right? So we're talking about a long time ago, where privacy still wasn't even as invested in by organizations, where there was a breach, and this was in the medical space, and we had to go through the whole breach response and figure out what might have been affected and all that. And then shortly after that happened, and I addressed all of the issues, and I put together a tiger team of discovery folks trying to figure out where data is in our system and get a good chain of evidence and all of that stuff. I was asked, basically I was going to be let go to make it look like I was the problem for the breach, when in reality it's like, I'm your first chief privacy officer. We don't even have procedures in place. That's what I was putting in place, and kind of the fall girl for negative news in this instance. And so that really put me on guard earlier in my career about, if you don't get buy-in from up high, if something goes wrong, you might actually be the first to be considered expendable. In this case, I could see why Ron really wanted to push and make this a public thing. And this is very compromising data to if it got out, or this very sensitive data about, sexual conversations and intimate desires, and whatever people are putting in chat messages on Grindr. You would expect that if you have that, ask for that to be deleted, that the data is deleted, not just your account is deleted and you no longer have access, or and so I think that that's really important thing, a thread to pull on. And so I've put this on LinkedIn. I support I'm with Ron. I don't think he would have gotten this far in bringing this wrongful termination charge, or even wanted to go that far if he didn't really have teeth behind his allegations. So that's what these are definitely personal feelings, right? These are clearly just based on not knowing all of the evidence, but just looking from the outside. I don't think it looks good to Grindr, right? I think someone with 17, 18 years experience in this field, it's I believe him over the company. And now it'd be really interesting to see what the company's response is to his allegations.
Yes, indeed. I should say, Grindr, for its part, denies any privacy issues and any impropriety in the dismissal of Ron. But of course, I know he's a well-respected privacy professional with a lot of experience. So yes, it would be very interesting to see how this one comes out. It's kind of one of those micro cases, one company, one person that says a lot about the broader industry, I think, and the dynamics at play. So next item, just before we move on to our main discussion, there's been an issue with, ChatGPT. So OpenAI have been in the news a lot, particularly in the EU, regarding data protection and security issues. So there's a piece of research here from a Singaporean cybersecurity firm, Group IB they're called, and they found over 100,000 ChatGPT login credentials for sale on a sort of dark web marketplace. Now it looks like these were scraped or stolen from browsers, from session cookies. When you log in, you click remember me, the browser sets a cookie and allows you to log in without having to put your password every time. And there's this malware called the Raccoon Information Stealer. I'm not familiar with this one until looking this up, that steals cookies, and those cookies can include login data. Now, I think this is pretty worrying for a couple of reasons. Firstly, I don't think ChatGPT offers, or at least doesn't force, two-factor authentication. So that could be a problem if someone gets hold of your credentials. And secondly, people are putting a lot of sensitive, personal and commercial information into this bot, maybe without thinking about what might happen if it ends up in training data, or indeed if their account gets hacked. So what are your thoughts on this one, Debra? I don't know if we can blame OpenAI for the initial breach, but I think there will be some issues arising as a result.
Yeah, so that's interesting. And keep in mind, I don't have inside knowledge or anything like this, but my thoughts include the fact that, first, I want to say that there's a difference between protecting personal data and then protecting login credentials, because now we're talking identity, and you can actually pretend to be somebody else, and then gain access to somebody's data that way or exploit them that way. So you can't just do one and not the other. You have to address security across the organization. And I don't know if there are enough security-minded experts that have wide enough understanding of how to lock down potential, access points, or thinking about threat modeling for not just the machine learning models, but threat modeling for the business at large. And I think very often when we hear about machine learning and now ethical tech, we are starting to hear about threat modeling, right? But what are some of the things in the model that could go wrong, or if you're learning best practices or things to avoid, and that is evolving as what do those threats look like, and threat criteria, and how do you detect them and all that. But if you spend too much time doing that, you're missing the forest for the trees, and someone can come in through the back door basically and steal all the credentials. Because if you, like you said, if they don't have 2FA, that's a very common, easy way to add a layer of protection for your users, that if you don't force that, then you're creating a vulnerability, a potential attack vector, right, that could harm your users. Not necessarily their data first, but their identity first, and then their data later on. So I definitely think that there should be more security and privacy-minded business architects beyond machine learning experts looking at the model itself. Then the second, there's so many issues around IP and machine learning models or AI, and I don't want to open that can of worms since I'm not a copyright or intellectual property attorney, but there is the challenge of how do you know if you're adding maybe some code from your company? Like I know my fiance is a hacker, so he's found it very useful to find new ways to find potential hacks, or potential vulnerabilities by using some code that he could put into ChatGPT. And I'm not sure how you do it, right? But then you can end up finding some smarter ways that ChatGPT recommends to do a thing, which might be, hacking something, right? So if you're putting in commercial data, so like whether it's your own company's code or you're putting in sensitive data about the company, this can be used to train new models. Now with ChatGPT, I don't think that's being like we have ChatGPT 5 now. That model's already been trained. So what we'd be worried about is that the data is going to be in like ChatGPT 6 or 7 or subsequent models, and the thing is we don't know. The problem is a lack of attribution to original sources, and it is a risk that is a little bit unknown right now. I'm not getting enough information when I go searching for OpenAI and ChatGPT about how they're fixing that challenge, or how they're addressing the challenge of, personal data is in your data set. Like, I do believe that they have since added like deletion requests and, DSARs and, all the data protection rights requirements that the GDPR requires in Europe. And then the CCPA and others, right? I do believe they're adding in some of that capability to find a personal data. I'm not sure how they're doing that. It could be like regular expressions where they're just looking for name, social security number, something that matches a type of, like a social security number or a healthcare number, whatever, right? So I'm not sure how they're doing it, so I can't really opine on if they're taking the right approach, but they're doing whatever they can to satisfy EU lawmakers. My concern is whether or not they actually, beyond the data protection rights, I don't want to say theater because they're doing the right things to add on, is the base model itself ethical, being scraped from so many places, no consent used to train the model on intellectual property and personal data. I think those are the areas that I wouldn't say keep me awake at night, but that I don't have a good answer to how OpenAI can solve.
Yeah, my thoughts exactly, Deborah. So they had this run-in with the Italian regulator, and since then they have implemented some measures to, bring the model into the software into some sort of compliance, but it's not clear how deep that runs. So I think with deletion requests, they are suppressing personal data associated with that person in outputs. Some people are saying, is that enough? Can they even really truly comply without deleting the model and the training data altogether? Anyway, it is a huge can of worms, as you say, so many, and that's not even before we get started on intellectual property.
Right.
Which is, not my area either. So let's talk a bit now about what I've designated as our main item, but we've got 10 minutes left on this. So US privacy law in 2023. Now, I'm watching from across the pond, but I'm watching very keenly, and there's been a lot going on in 2023. So I'm going to run through quickly where we're at, and then I'll ask you, Debra, some questions about how to approach privacy in the US, given all this patchwork, as they call it. So this year, We've got 5 laws taking effect, signed in previous sessions. We've got California, CPRA, which amends the CCPA. That's done. That came in effect on January 1st. And now the very own privacy regulator, the CPPA, will start enforcing in July, and I think they're going to want to show their teeth. We've got the Virginia Consumer Data Protection Act, took effect also on January 1st. Then all the other laws look a lot like Virginia. So these are the new Virginia-style laws. Poor California started off the privacy trend and has been rejected their kind of model of privacy law. So we got Connecticut, Colorado, and Utah, all taking effect this year from July onwards. And then the following states have signed comprehensive privacy laws this session: Indiana, Iowa, Montana, Tennessee, and Texas. Surprising one for me. It's pretty impressive as well, comparatively. It's not a weak law. And then we've had other bits and bobs too. Florida passed this Digital Bill of Rights. You'll notice a slight note of disdain in my voice as I repeat the title of this law, because it's not a Bill of Rights. It's actually not a very good law. We've got Washington My Health, My Data Act, which I'm sure you're familiar with, Debra, which is a seriously robust and broad health privacy law.
Yep.
And Nevada has copied that too, but theirs is a little less. It's a bit narrower. So we've also got the FTC on a bit of a rampage. I think 7 or 8 privacy-related actions this year already. So we've got about 20% of states now, well, exactly 20% of states with comprehensive privacy laws in place. How are you feeling about the direction of travel, Debra, in broad terms? What are your thoughts on what's happening in the US? Do you think it's a positive move? Do you have any issues with how things are going? What are your thoughts?
Yeah, it's a good question, since we've been trying to get laws passed for so long, both federally and state, that I've stopped paying attention on the play-by-play on how what bills are in state legislatures and what's going to pass and whatnot. It's like when something passes, I'll kind of give it a little, finally give it some credence. But I guess what I'd say is, I think it's good if everybody wants a federal privacy law, right? But this is why we can't have nice things. It's because no one can agree on what goes in that law. And the things that we can't agree on have nothing to do with privacy itself. So it's a lot of lip service from politicians about whether it's, on the left or the right or whoever, of we need a strong privacy law to hold account, the big tech companies and others, right? And so in absence of that, and with California being a very strong law in CCPA, I'm not surprised by the promulgation of other state laws that are endeavoring to, put something in place. Some are going to be weaker than others, right? So the California folks' perspective is, I don't want a federal law that's less protective to humans than CCPA is, right? We want something GDPR-like, but there's, each state now is kind of making that decision, and some of the laws are, really don't protect people to the same degree, and others do. I live in Washington State, so this Washington law around what is it called? My Health,
My Health, My Data.
My Health, My Data, I think is a really exciting law. I think that one is particularly strengthening the perspective that even though you are not covered by HIPAA, federal law for privacy around protected health data, you still have an obligation that is very clear at the state level of, needing to get permission and having to kind of go through the same privacy protective, having the same rights, being able to ask about what data you have on me, being able to, see if I have it amended or complain about it, all those things. That is a helpful law that is going to be in this age of post-Roe world where, just the fact that you travel to a clinic to ask questions about your sexual health could actually land you in jail if it was about abortion and you were seeking one and past past when you were allowed to have one in Texas. So I think that this is really firming up our healthcare protections in our state in Washington, given the promulgation of in some of these states, anti-abortion laws, and making all of the conversations that people are having around maybe seeking abortion or location privacy, adding more location privacy requirements so that you can't, start tracking someone and then sell that data to law enforcement, for instance, without their permission or knowing that you're even giving this data to be tracked. So I think it's essential. I'm really excited about that one. Some of the others are just, they need a state privacy law, and they're either going to be better or worse than CCPA. I don't believe we'll ever have a federal privacy law, but that is the utopia that I would like to work towards. I have a lot to say on this, but instead
the
of
Washington law,
rambling,
the Washington law could have, even though it's a health privacy law, could have a bigger impact than a lot of these Virginia type laws. Because it's really strong, the requirements for consent or it's either consent or providing the service you're saying you're providing. Pretty much that's it. If you think about it in GDPR terms, those are the two legal bases for processing health data. And health data is pretty much anything that even slightly touches upon someone's health. So I think you're right there with the Washington law could be the most impactful. So let me just ask you, I have recently been trying to write a privacy notice that kind of represents the high watermark across the laws coming into effect this year. It's really hard because some of them, you have to opt into this bit and opt out of that bit. And, this is sensitive data here, but it's not here unless it, what do you think? What sort of approach do you think businesses either are taking or should be taking to try to, if we ignore any European operations, try to meet the requirements of all these different states across the US, assuming that they are slightly different here and there? Is there a good way to approach this in a broader way?
Yeah, so you have to kind of also work with your business goals, right? I mean, in my ideal world, if I were working for an organization and helping with this, I would say that we need to figure out what are the requirements, like the highest bar that needs to be met, and make sure we meet that. And so, like, basically, what's the most restrictive laws? And now let's build our compliance GRC programs around making sure that we're meeting those higher bars. What I've seen companies do in the past, like let's say they're an advertising company, right? They're going to be like, well, trying to preserve their business as it is today to the best of their capability. And then, let's try to anonymize this, or let's try to do, right? So trying to preserve the status quo while, meeting the highest bar is really tough. So, I would say that businesses really need to think about what the future of privacy looks like versus like this Web 2, big tech, big data, collect all the data you can and figure out a use for it later mentality. They have to like grow up and get past that and now be like, how are we going to earn trust and demonstrate that we are responsible with identities and personal information, and that people feel safe using our product. If they don't change to that mindset, I don't think there's the mandate to actually make privacy embedded into their organization is going to be very, very difficult, if not impossible. And I've seen attempts at, oh yeah, we've got these new laws, let's go get compliance with them. And if you're only looking at how can we literally meet the letter of the law and say we're doing these risk assessments and say we're doing, DSARs and all of these things, that if that's all you're looking at, you end up having just like output into your systems of the bare minimum. Like you'll have, here's all the data we collected about you, but and return a DSAR request, but it won't be legible or understandable by the individual, right? And so like how much trust and understanding are you going to get from that human being? I mean, so there really needs to be thought around privacy and not compliance, so to say. And remember that when we talk about privacy, we're talking about people and not harming people, not just how do we reduce the risk to the company, right? And I feel like that if you can align how do we reduce risk to the company with a mandate that you also have to reduce privacy harms to individuals, I think that nice alignment, and you get the executives on board with those things, in addition to some other, good governing, good governance generally. But those things are necessary in order to meet the moment. If you're just doing like, hey, let's get a consulting firm in here, tell us what we need to do to comply, and then go implement that, you're never going to get like a systemized way of, as new laws are coming in, you need to be kind of agile, right? You need to be able to go, we're still moving the business forward, but we're taking this new law and we're going to implement the requirements into our business. If you don't have a process for that and you're just whack-a-moling it with each new state law, I think that makes it a very difficult way of approaching it, and you might run into a lot of roadblocks, and then having the conversation too much in your organization of, well, why are we doing this, or could we get around this by doing it this way, rather than like, let's get trust, and let's get people to want to believe that we're responsible with personal data, and what's good architecture for that. You want to engage your engineering team so that they understand their part in coding up new apps, or architects developing new system designs. These things are super important. So I would say that you really need to get your privacy engineers involved as well, and if you don't have them, hire them.
Good. So rather than looking at each provision of the law and trying to figure out, how to look as though you're complying with it all, or perhaps tailoring to each state, think of this as an indication of a sea change, really, that you can either respond to in a company-wide way that really integrates the values that these kinds of laws represent, the future of privacy, as you put it, and think about the core of your business and the engineering side as well, and how you can adapt and be agile so that you don't need to worry every time a state passes another law.
Right.
Do we have to change this tiny bit of our operations, or what are we doing in this state?
Yeah. Do you need a minor change in your privacy notice, or do you need to like completely put in a new, process in your organization, right? Like it run the gamut of depending on the law.
Thank you, Deborah. Well, that's a great insight, and we've run out of time now. I would just like to acknowledge we had an audience comment about our discussion earlier. Always like to raise these. So, Ugur, thank you for your note. It is a hard problem to remove someone's data from a machine learning model or artifact with the weights and so on after training is done. That is very true, Ugur. This is what makes me wonder, really, whether some of these LLMs are compatible with EU law at all, to be honest. But there could be a number of different approaches by regulators. I think that it looks like they are compromising somewhat, meeting these big AI companies in the middle. So look, thank you so much, Deborah. I will just say another word about Bravado, and we're ending on the engineering note there, which is highly relevant, because Bravado is all about bridging that gap between privacy and engineering teams, so you can really put this stuff into the heart of your business. It's a privacy code scanning solution, and it's all about privacy by design, privacy engineering, getting this stuff right at the start, shifting privacy left, as you might say, Deborah. And Bravado AI is really worth a look if you are, if you have an engineering team or you want to get things better at the very heart of your business. Thanks again so much, Deborah Farber, for joining me. It's been a pleasure to talk to you. I've been hoping to have a chat with you for some time.
Likewise.
So I'll be back here in 2 weeks' time. And thank you to anyone watching as well for joining us. Thanks, Deborah.
Thank you.